Hey there, gang. Another session, the final part of week 7. I've combined these two last lectures into one, both about identification evidence. So get ready, strap in. It's me, Jason Shin, for another class. Stretch it out, move around, and let's get into it. So yeah, I've combined the background and law part for this one. It's a bit more constrained than the prior class about opinions. There's only about 3 rules to know, so hopefully it's a bit easier to grasp. I'll try to only go about 20 minutes. So eyewitness identification evidence is it draws its relevance in quite a different way than opinion evidence and tendency evidence. With tendency, the relevance was a bit more removed. You have to draw a connection between someone's previous acts that create a propensity to do something, and that propensity is then related to the charged act. Here, it's much more direct evidence. This is an identification of the accused at some relevant part in the alleged crime. So you can see that as being both quite powerful and relevant evidence, but also potentially very dangerous if the eyewitness is wrong. Many courts, many commentators have said that there are a few things more dangerous than a confident but mistaken eyewitness. And you can understand that, I think, because, and I talked briefly about the Stephen Avery case, and you can understand that, I think, based on the idea that the eyewitness doesn't know they're wrong. So they're not lying in their own head. They believe themselves to be correct, and they come across as very credible, but they might be simply mistaken because human memory is fallible. They have to have properly encoded it, so they had to have properly seen the person to have to remember them, and then they have to be able to recognize the person again. There's many steps in that process in which things can go wrong. In the United States, 70% approximately of folks who have been exonerated based on subsequent DNA testing have in 70% of those cases was there a faulty eyewitness identification. Only 6% of the known Australian wrongful convictions, including cases like David Eastman's and Andrew Mallard. Why is it lower? You could argue it's possibly the procedures here are a little more careful. Memory, I don't think, works differently in Australia and the US. I don't have any evidence to support this, but I know that the US and Canada have in many jurisdictions similar procedures, and they also have a lower rate of these known wrongful convictions. I suspect one key reason is that in the US, the laws surrounding sexual assaults are much more punitive. People are in jail for longer, so there's a longer time for them to be, for the wrongful conviction process to work, whereas people here are released before they would go through that whole process on cases like these. Scientific research, field research finds that in a whopping 25% of cases, people pick the filler in an eyewitness lineup. So in 25% of the time, about 23.7, they pick someone who is not the actual person who did the crime. which is high and concerning, suggesting we need rules to safeguard against human nature. So the factors that affect eyewitness memory and selecting the right or wrong person, psychologists have divided these into two categories, what are known as system and estimator variables. System variables are those that the legal system can control. I'll talk a bit more about those later, but these are things like the way in which you construct the lineup or parade, the type of photographs or people that are in them, the importance of them being double blind such that the investigator doesn't know who the suspect is, the way in which questioning happens, and the way in which we record confidence statements. This has been one of the most contentious topics in psychology and law. Hundreds of papers, probably thousands of papers on this. The relationship between a witness's confidence and their accuracy. I think it's safe to say that the correlation there isn't as high as people think. We're inclined to trust confident eyewitnesses, but that becomes especially problematic if the confidence statement isn't taken early on, because confidence hardens. So after someone has selected a person out of a lineup, that's when their confidence is the most diagnostic of their accuracy. If in the months and years up to trial, people have gotten used to the idea that that's who they selected, they've gotten more and more confident, and when they actually are in the courtroom, their confidence is not that diagnostic of their accuracy. Estimator variables are variables that are out of the system's control. We can only estimate them. We can typically only instruct jurors about the possibility of these factors playing a role. Large one is the own race bias. This is also very well studied. It's the finding that people typically are better at identifying people of their own race, and much worse at identifying people of other races. Other factors like, was the person paying attention when this happened? We know that our attention is limited, and if we aren't paying attention to specific features of someone's face, then we're not as good at identifying them. And again, the system really can't change that, just fundamental human nature. Many other factors. You could teach a whole class on this, really. I won't spend too much time on it, but also if there's a weapon that can distract people and they don't encode the face as well, general limitations of human memory. We also know pretty well that in-doc identifications, so like what we see in one of the cases that we'll look at, Tahir, I think, are just not very diagnostic. So if somebody points to the person in the dock and says, that's the man who robbed me, that's the person who robbed me, it's just not unless there's been a prior lineup that they selected that person out of to support that, it's just really not very diagnostic, because there's only one person to choose from, and that person is in the situation that a criminal is typically in. It's much more diagnostic to select them out of several similar other people. That actually gives us a better idea of the accuracy of their memory. The same with show-ups. Show-ups, I think you'll have read about in one of the assigned readings, but that's when you have the witness in the police station and you bring in the suspect and say, was that them? If that's the best way, if that's the only way you can do it, then there are procedures about how that should be done, specifically telling them that this might not be the person, because there's a high degree of such suggestion in situations like those. There isn't a scientific consensus about whether live parades versus photo ones are better. And oftentimes the photo ones are just more convenient. One of the best resources on this, and I suggest you take a look at it, is a recent policy paper that was put out by a group of psychologists who also got feedback from the entire community over an 18-month period about what are the recommendations that we can give that have the most scientific support behind them, the strongest scientific consensus. And they provided nine of these. 4 of them, this is the same group that about 20 years ago created a similar document, which had 4, and now they've added 5 more that they think are safe to provide as these consensus statements. These are system variables, things that we can control. So I'll just go through these very quickly. One of them is to have a pre-lineup interview. You want to be able to warn the witness about certain things, get a baseline before they're exposed to the face of potentially the accused. You want to tell them things like, well, first get the description so you know how to properly construct the lineup. You want to tell them in the days to come, please avoid talking to other witnesses so that you don't contaminate your memory, things like that. You want to base the lineup on an evidence-based suspicion. Don't want to just throw in 9 quite hypothetical people into a lineup. This has to do with the statistical concept of base rates. If you throw a bunch of people in there with a low chance of them actually being the culprit, then the person's selection of one of those people isn't actually that useful, especially knowing that people, just when the person isn't there, or people pick the filler 25% of the time. So you want to boost your chances of having someone pick the actual suspect. This is one of the original ones. It must be double blind. It really should be. There are many ways in which an investigator who knows who the suspect is can unconsciously point you towards that person. Just the length of time, the way you position your hands when you're pointing at different photographs. There's all these different ways. They're all pretty innocent, but it just happens unconsciously. This is why. This is the same reason that drug trials are double blind. When picking the fillers, the best strategy, and this isn't, there isn't a strong consensus on if the fillers should be based on the person's description of the person that they saw, versus people who look similar to your suspect. But there's pretty clear consensus that there should be at least 5 fillers and no one should stand out. Pre-lineup instructions should include things like, I, the administrator, don't know who the suspect is. The culprit might be there, they might not be. It's okay to say, I don't know. And that the investigation will continue even if no identification is made. So all of these are sort of encouraging you to not feel pressure to select somebody, which you can imagine somebody might do. The immediate confidence statement has to do with, as I mentioned before, the fact that confidence hardens. So you want to get someone's confidence right after they select somebody. Video recording, we know from some research that police will inadvertently leave details of the identification out, and that this can really encourage police to follow best practices. There was a case, the Crown and Afu, in which there was the possibility of that happening. In this case, in which the witness didn't select anybody the first few go-arounds, then the recording equipment was turned off that was recording the identification procedure. And it was during that time that he selected somebody, which gives a sense that there might have been something going on, some reason that he was encouraged to make this identification suddenly after the recording was turned off. That's the importance of keeping the recording going during the whole time. It gave sort of the appearance of bias. And this was actually one of the few cases in which an identification was thrown out. You should avoid repeated identification procedures. This has to do with the idea that once you've selected somebody, it's hard to remember if our source memory is poor, is what I'm getting at. It's hard to remember if you selected that person because that was the person you saw, or if that was the person that you selected before. And you might get those confused. And again, show-ups should be avoided whenever possible. But if you do have to do a show-up, this white paper gives you the best practices for that. So if anybody's watched the television show Clone Wars, which is a great show, I highly, highly recommend you watch it. The Padawan at the time, Ahsoka Tano, before she left the Jedi Order, Anakin Skywalker's Padawan, had her lightsaber stolen, episode 11 of season 2. Went through an identification procedure. You can try and spot the problems with this procedure. One is that I think there's a bit of suggestion going on by the part of the person administering it. It's a cross-species identification. They're all fish. Ahsoka Tano is not one of the fish species. And should they be showing them green fish, orange fish, yellow fish, or should it be all the same color of fish? It seems like they're too different, and she's just going to pick the one that's purple because that's the one, because the robber was purple. So give that a watch. Let me know what you think. There's probably some that I'm missing. Finally, you might want to know how well do New South Wales police procedures stack up to these 11 recommendations, these 9 recommendations. New South Wales is the best of any Australian state that we have data for, especially with the original 4, which are kind of the main recommendations. The only thing it doesn't do is collect the immediate confidence ratings, which is problematic. And some of the new 5 it doesn't follow as well, but we'll give them a pass because that paper just came out in 2020. New South Wales, the police handbook is not online anymore. It used to be, so there's a bit of a problem with transparency there. But if you want to take a look at it, I downloaded it. So as we go into the rules and the cases, a few things you might want to think about is acknowledging these risks and these psychological findings. How does the UAL manage it? Is it sensitive to the risks that we've looked at? And would you change the rules in any ways? So let's move on to that now. 4-4, week 7, we made it. So first, it's important to note that the Law Reform Commission was live to these challenges. They reviewed some of this research. They noted that the common law had not prevented miscarriages of justice to the degree that you'd like to see. That simply having the possibility of eyewitness identifications being excluded as part of the discretions, which we'll talk about next week, 135, 137, was not enough. So they came up with the rules that we have now under part 3.9. First, the dictionary definition of an identification is specific to the defendant, the accused. So this section is not going to apply beyond that person. And for clarity, section 113, it will not apply to civil matters. Sound good? Section 114 creates an exclusionary rule for visual identification evidence unless certain criteria have been met, typically that there has been an identification parade. But you don't have to do that, as we'll see in the cases, if it's not reasonable. And in other circumstances, like the defendant refusing. Or perhaps better to say, it's not reasonable to hold a parade if the defendant refuses to participate. Parade is not defined in the Act. There are rules about parades in the Crimes Act. So if it's a Commonwealth crime, a federal crime, then you'd look to that. Section 115 has the rules about picture evidence, identification through picture evidence. Here, you can read this for yourself. It gets a bit technical, but the rules include things like the photo can't suggest that the people are already in custody. We'll see that in the case Pace, I believe. And when this identification is admitted, there's a requirement that there be directions to the jury about the potential risks of this. Doesn't give much about the substance of that. There are standard instructions, and a helpful common law case is Domican. We will deal with this more in proof when it comes to instructing the jury about how to weigh up the evidence as to whether the one side or the other has proved their case. But directions are required. All right, Taher is a case about whether or not it was reasonable to not have a parade. There was an in-doc identification of the accused by a man who says that he had a conversation with Taher as he was running through his yard. The thing to note here was that Taher had dark skin and long black hair, somewhat unusual looking, I shouldn't say unusual, distinctive, someone who the police said was hard to create a parade because there just aren't many people that look like Taher in the community. I suppose if this was in the 80s, then the hair bands were a bigger deal. The long black hair might have been easier, but who knows? And the court said, okay, yeah, sure, maybe it wasn't reasonable to create a parade the next day after, but you had a long time. You had months before this went to trial. You could have done a parade at some point then. You could have assembled enough people that look like him at some point. So it was not saved by section 114 2B. And here you might say that perhaps some of this should be guided by the science of lineup composition from the readings. Essentially, the police was saying that we couldn't do a proper scientific lineup, so it was not reasonable to, which I think the court said, which, yeah, that's a strong argument, but you could have done it at some point. Alexander and the Queen provide some guidance about how to construct a photo board. So a photo identification, picture identification. Talks about many of the principles that we talked about from the science. Especially is concerned with displacement effects. And we'll see that a lot in these social media based identifications, in which if you see the person on social media, is it really that diagnostic to pick them out of a lineup afterwards? Because you might not be selecting the person that you saw, but rather you might be selecting the person that you saw later on Facebook. We can look to Peterson and the Queen. The complainant stabbed, finds Peterson on Facebook, and there was never a parade done. The Crown says, well, it wouldn't have been reasonable to because he's already found this person on Facebook. He's just going to select that person. There's this risk of a displacement effect, as noted in Alexander. The court accepts that. Also argues this is low probative value. Court, as we'll see quite consistently with other decisions, says reliability tends to go to weight. And if there's a risk of the jury overvaluing this, we can compensate with instructions. Now, I'd note here that there really isn't much evidence that these instructions work, but that's what we have. MA and the Queen, there was 2 identifications made by someone who worked at I believe at a hotel. She selected him later from CCTV footage from a previous time he visited, and later she saw him on the street. There's the guy. There's the guy that stole my lightsaber. The accused for the first one says there's been some real unfair prejudice here. This CCTV identification was not controlled by us. There weren't these early stage descriptions taken. It didn't follow best procedures, essentially. The court said, no, instructions can help, as they always say. And they said this was mere oversight. But it's unclear to me how the fact that there was a mistake gets at the unfair prejudice. Maybe I'm missing something. And the second one, they said, yeah, sure, there is this risk of displacement, that she saw that she's identifying the person she saw in the video is not the person that did the robbery. But again, there are instructions. And also, this was a very distinctive looking person, suggesting that it's not someone that you could mistake for somebody else as easily or get the memories mixed up. Finally, a picture identification in PACE. The accused was picked out of a photo book, and the accused argued that the photo book suggested that the people in it were criminals, which offends, I believe, section 115, sub 2. For several reasons. One, it was all head and shoulders pictures. I suppose it looked like mugshots. They had ID numbers on them, which, again, you might associate with mugshots. Had a title that was, I guess, could argue suggestive in some ways. One of the pictures had a height scale on them, and some of the backgrounds looked like they were a bit institutional. So they taken together, these might suggest that these were all photographs taken of people who were arrested. And the court said, no, you need something more than that. It must more clearly call to mind the idea of custody. These were also just as consistent with motor vehicle licenses. And the other qualities of the book are, sure, you could draw some connections to this being a book that the police would keep of criminals, but it didn't necessarily lead to that implication. From my point of view, I would say that it wouldn't be that hard to make this book more innocuous. I don't know why the police just wouldn't do that, but maybe they have now in light of this case. Okay, that's the end of opinions and identifications. I would also think, I do think that at common law, at least, identifications are opinions. I'm not really sure anything turns on that characterization because they would meet the exceptions for a lay opinion, being personal experience and necessity of using that language. It's easier to say, that's the person I saw versus the person I saw had a small nose, big ears, gray hair. It's the holistic opinion is more informative in some cases than the featural one. Okay, well, that's it. I hope you had a great time. Hope you're enjoying your break. If you're just watching this for fun, I feel bad for you. Okay, thank you very much.